today's Q&A. This may have been said last week, but if it wasn't, I wasn't here. It was nice to see some of you in person at CA Day about 2 weeks ago. It's nice to be able to connect. Even though you see my face on a screen, it is sometimes nice to be able to put a face to a name from the Zoom. So for those of you who attended, it was nice to see you. For those of you who didn't, maybe next time. Uh, we'll just go over our general housekeeping and instructions, and then we'll get into the questions. We will likely have time for questions today, so feel free to put them in the chat. If we don't get to them, submit them to info@condolaw.net. If we can't answer that, we'll tell you because we can't give legal advice. Remember, this is general legal information. It is not legal advice. You can only get legal advice from an attorney that you have an attorney-client relationship with in that private setting, so not this open forum. The chat function is intended for questions or requests for clarification and commentary, not legal advice. WSCAI has a resource guide for UCIOA for all for sale. So for those of you who are getting worried about it, I know we talk about it every week, but there is a resource guide you can get, and the proceeds of the sale go to support the Legislative Action Committee, which works with a lobbyist in Olympia to advocate for community associations' interests within the legislature. So to the extent you're unhappy about some of the things in UCIOA, contact your legislature because they can change some of the, well, they can try to change some of the things. As we've been reminding everyone, for UCIOA communities, some changes took effect July 27th, and we're going to keep reminding people that several provisions of UCIOA will become binding on all communities, regardless of your current statute, effective January 1st, 2026. The big ones relate to changes in meetings that I know we've talked about a lot and we'll probably keep talking about, and also collection notices. And as I mentioned before, we might not be able to answer a question submitted either in advance or through the chat for various reasons. Some of them include if it's asking for too much legal advice or we don't understand the question or various reasons. We'll try to tell you if we can't answer it, but don't be surprised if we just scroll it and move on. And then finally, several associations have inquired about revisions to their bylaws and their declarations before the end of the year. So if your goal is to do that, we are almost at November, so the end of the year is rapidly approaching. It might be that you want to include it in your budget for next year. That's totally fine. Contact your association attorney for pricing so you can include that in your budget, as it is now budget season. The bylaw revisions are relatively straightforward and could still be accomplished. We'll talk about this later, but there is a question of whether or not you need to revise anything at all. So like I said, we'll talk about that. If you are interested in revising, now would be a good time to start planning financially for it. As a general disclaimer, be wary of working with non-attorneys to revise your governing documents. Your governing documents are a legal document, and we recommend that they be revised at least with the review or consultation of a licensed Washington state attorney. Ken, do you have anything to add on that before we jump into the first question?
No, I'm good, thanks. And I'm taking odd questions today. So the first question is, can you confirm whether there are any statutes that require an association to reach a specific reserve funding level by a certain date? One of our board members believes there's a new requirement stating that associations must be at least 70% funded according to the reserve study within a few years, but I haven't been able to find any reference to that in the statute. So I guess the first thing I'd offer is that anytime someone starts quoting new laws to you, ask them to give you the citation. Have them tell you what the statute number is. Because we do get a lot of these questions where it's, well, somebody told me the law is changing. And in this particular case, we are completely unaware of any law that relates to the percent of funding that an association has to have. So before I just tell people they're wrong, I ask them, what statute are you citing? But I can offer on this one, there is no obligation in WUCIOA or the HOA Act or Condo Act to reach any level of funding. There are some industry standards for the banking industry, but even that doesn't relate to an obligation of the association to achieve any level of funding. It just relates to the interest rate the bank might want to charge you because they might perceive a different level of risk to their borrower if the association is poorly funded. Okay. The statute requirement that relates to reserve funding is just a disclosure requirement, and it's in RCW 6490-525, which applies to all communities. And all that says is that the association has to tell the owners what the recommended contribution rate for the following year is. In other words, what did the reserve study professional recommend the association contribute in the budget year that you are now approving? And if they've recommended a contribution that's higher than what you're actually contributing, then that should be noted in the disclosure to your owners. If they're if the budget is contributing less or more, that's something which the owners should know. The other piece of it that you disclose is the difference between fully funded and what you actually have. So you're supposed to disclose for each unit the deficit or surplus in reserve funding that you have compared to the fully funded balance for the community. And it's a relatively straightforward math. The reserve study is supposed to calculate what the fully funded balance is. You subtract from that your current bank balance in the reserve accounts, and you get a number, and that is the deficit for the entire community. And then you multiply that by the percentage of ownership interest for each unit, and you get the percentage or the deficit for each of the units. Most reserve study professionals will make a recommendation, which is based on their belief about how soon you should reach 70% funded or 100% funded. There is a definition for a fully funded contribution, but it doesn't require that you be fully funded for another 30 years. And every year you update your study, that 30 years moves out one more year. So it's always 30 years in the future. It's not like after you've reached 15 years, you have an obligation to now be fully funded in 15 years. So if you've got questions about that, you can certainly talk to your reserve study professional. But the other thing I guess I would note is that the reserve study professional is only required to do your reserve study every 3 years. The board or a manager or an owner can update the study in the interim years. And usually those updates would reflect what your actual bank account balances are and might reflect the removal of items that have actually been completed. So if you put a new roof on your building, that the costs associated with that should come out of the reserve study. Did you have anything you want to add, Katie?
And before we move on, there was a question that is related to this. I think you started to touch on it, but what if you disagree with your reserve study professional?
So the amount which your association chooses to contribute to reserves in their budget is entirely at the discretion of the board. So if you disagree with the reserve study professional, you simply budget a different amount. And you can state that you disagree with them, but the reserve study professional's opinion is their opinion. And so you don't get to change their opinion. Now, I did reserve studies for many, many years and certainly got into arguments with some owners about what they thought should be my opinion. And I will offer, it is possible if you give me better information, I would change my opinion. So I've had clients who went out and got contractor cost estimates because those might be more accurate than the cost estimating software that the consultant is using. Or I've had clients get engineers' opinions or architects' opinions about what the useful life of a building component should be, because that might differ from mine and they may have better qualifications than I have, or they may perform a more thorough investigation than a reserve study professional has. So it is possible to provide better information to a reserve study professional to get them to modify their opinion. But if you're just arguing with them about their opinion gets to stand, but you don't have to pay any attention to it and follow it. You just have to report the professional's opinion to your owners in the disclosure as required by statute.
All right, so our next question is, what uses of video recordings by owners are considered inappropriate? Specifically, may an owner submit complaints alleging rule violations based on footage from cameras monitored remotely, for example, from a second home or out of the country or whatnot? So first, we have discussed this question before, so we may not go into as much detail today. You can look for this in our other videos, but we will answer this generally. The board makes decisions about violations based on objective information and adequate inquiry. And they can use videos to help form their decision of adequate inquiry if videos are submitted. Whether the video be from someone standing on the street corner holding their cell phone or a doorbell camera pointed at a common area. This question about the board's choice is about the board's choice to enforce, not about an owner's use of technology to report a violation. So even if an owner were to use a remote video to report a violation, that does not mean that the board needs to find that the violation requires enforcement or any action be taken by the board. Meaning the form of the video, regardless of how it's submitted, is just another tool to aid in that objective information and adequate inquiry that the board has to use to decide whether or not to take enforcement action. One option, if the board does want to do this, is you could have a video policy. We have some clients who have video retention policies for storing footage from an association camera and what it could be used for. You could have in your policy that the board will consider video evidence in violations. Again, you don't need that in your policy. You could just use it anyway. But if you're concerned or this is an issue, you could flesh things out more for your community. If you're concerned about having basically cameras that are attached to the outside that can be accessed through Wi-Fi, like a doorbell camera or a security system, you could have rules about installation of cameras within common areas rather than units. But I want to remind everyone that there's no expectation of privacy for owners in common elements or areas that are held open to the public. So to the extent that you're concerned about using video footage of someone doing something in a common area because it violates their right of privacy, there is no right of privacy there because you're holding yourself out to the open. But again, this question is really going back to the board's ability to use video footage, regardless of the source, to determine a violation. And the short answer is they can use it, but they could also use it to determine that no violation exists. Ken, do you have anything you want to add on that?
Yeah, they could determine a violation existed, but it is not of consequence, and therefore no enforcement action would be taken. Anyway, next question is, if the association distributes an annual meeting schedule to all owners that includes a skeleton agenda, such as approving prior minutes, um, change orders, an owner forum, committee reports, financials, etc. What is the proper timing and level of detail required for a clarifying agenda notice prior to each meeting? So I'll offer, this is a good question, which I don't have a great answer for because the statute is either confusing or unclear. So the statute, which is 6490-445 and applies to everybody starting January, Section 2F says that unless the meeting is included in a schedule, then a notice must be provided 14 days in advance of the meeting. And then it says that the notice must include the agenda of the meeting. So this could be read to say that if you have a schedule of meetings, you don't have to provide any agendas because you didn't send a notice. You weren't required to send a notice, and therefore no agenda is required to be included with the notice. But it could also be intended to mean that you're supposed to give notice of all the agenda items you know about to all the owners before every meeting. And we don't know what the legislative intent was, which is what a court would try and figure out. So the low risk option would be provide a way for your owners to know what the agenda is going to be. So if you know you're going to be discussing the budget at the October board meeting, you could include that on your schedule that you give out to the owners. If you know that you're going to address a specific contract, like a roofing contract at a meeting, you could send a notice out to your owners for that. And part of the question is going to come down to whether you're acting reasonably and in good faith. So it might be reasonable to provide email notice to your membership about an agenda item which is unusual or new, like a roofing contract. It might be reasonable to just send out notices anyway. If you've got a lot of owners willing to accept notice electronically, that makes it low cost and easy to do. The statute was revised this year to allow for as little as 7 days notice for those things which could not reasonably be foreseen. We don't really know what the legislature means by that either. And it's different than emergencies, which don't require anything other than just reasonable notice. But if you are being particularly concerned about minimal risk, then I would send out an agenda for every meeting if you've got anything other than your standing items on the agenda. And if that seems onerous to you, then I would look for something like an ability to post your agenda on a website, preferably at least 7 days in advance, so that if owners care about the agenda, they can look it up and decide whether or not they want to attend the meeting. Part of the purpose of the agenda, we believe, is so that if owners have a concern about an agenda item, they can show up at the meeting and express their concerns to the board during the owner comment period, which is now going to be required at the beginning of every board meeting. Anything you want to add, Katie?
Just kind of going off that, well, we don't know the intent of the legislature for this specific sentence. The overall theme for this last legislative session that brought about these meeting changes was correctly or incorrectly brought about because of accusations of a lack of transparency. So the goal with the whole changes to the meeting statute are to increase transparency for association boards. That's why now everyone will have an open meeting and there's the owner comment period. So if you take that philosophy and you apply it to this specific provision, that's why we're saying the least risky option would be to provide the agenda that the board is going to work off of. As Ken mentioned, it's so owners can comment on specific things, or they could decide not to come because what they want is not on the agenda, or they don't care that you're talking about planting trees, whatever it may be. But if you think of trying to be more transparent moving forward, that may influence your decision on whether or not to provide an updated agenda.
And you will have to plan better for how you deal with community association business in order to comply with the intent of this new statute.
Yes. So a short follow-up question to that we had was with the meeting statute 6490-445, which is what will apply to everyone, is it required to send the agenda 14 days in advance of a board meeting or just the notice of the meeting? So this question is kind of asking the opposite of what we just answered. So basically, if you're not doing a standing meeting notice, you're not doing the annual schedule that you send out in advance, you need to send the notice and the agenda 14 days in advance. Basically, all this boils down to is if you're sending a notice, send the agenda with it.
Yeah, the statute says, and I'll quote, that the notice must be given at least 14 days before the meeting and must state the time, date, place, and agenda of the meeting. So if you have to send a notice, you have to send the agenda. The question is just, can you avoid sending an agenda if you don't have to send a notice? And we don't know the answer for sure. I suspect that the intent was that you have to include the agenda to the owners. And I will also note there are some specific items which the board has to include on the agenda of a meeting or in order to do. So like adoption of rules, at least under WUCIOA, you're going to have sent proposed rules out to the owners in advance of the board adopting them. So you're going to have to tell the owners at what board meeting you're planning on adopting those rules so that they can comment to the board before the board adopts the rules. Offering a comment period after you've adopted the rules is not going to comply with the statute.
Before we move on, there was just a quick follow-up, which is in the more detailed advanced agenda, do we need to spell out the planned motions or just state the subject? And I would say just stating the subject, if you don't know what the motion's going to be, would be sufficient. Meaning if you're going to discuss whether or not you sign a contract, you can just say discuss roof contract, and then the motion can be made at the meeting whether to not to approve or reject the contract. Ken, do you?
No, I would agree with that, though I do certainly have some clients who are trying to streamline their meetings and make them faster. So board members or even the manager will put the text of a proposed motion into their agenda so that all the board members know what it's going to be in advance. If there are supporting documents, they are included with the packet to the board, and it can make some of the action items go much faster. Right, it's my turn again?
Yep.
Okay, so I'm in 6494-55, which is the voting statute under WUCIOA. Does electronic voting mean by email, or does it have to be a third-party voting platform? So the answer is email qualifies as an electronic means, as would a third-party voting platform. So the statute, WUCIOA, does define what electronic means in the definitions section. That's section 6490-010. And so it talks about basically any variety of electronic communication, which is going to include email, text messaging, and any kind of web-based communication. But I will also note that 6494-55 about voting does not apply to all communities starting in January. It doesn't apply to all communities until 2028. And unfortunately, the HOA Act and the Condo Act do not address electronic voting. Those statutes were intended to be replaced by WUCIOA with the WUCIOA for All legislation. And so they were not updated in 2024. So we've still got this gap of 2 years where you've got some uncertainty because the HOA Act and Condo Act do not specifically allow for electronic voting, though the risk of using electronic voting that would comply with WUCIOA is probably small. Anything you want to add, Katie?
No, I think you covered it. So our next question is, our association invites all its members to participate in its monthly board meetings via a Zoom link. Our Zoom package automatically records the meeting. An audio recording and transcription are available for members to listen to or read later. How do we ensure we are not violating Washington law regarding recording conversations? So for those of you who don't know, there is a law in Washington that prohibits the recording of a private conversation, basically between two people, sometimes maybe more, but usually between two people without the consent of those people. That would not apply here. So there's no expectation of privacy, as I mentioned earlier, in a place where you hold yourself out to the public. So for example, this Zoom meeting right now is not, there's no expectation of privacy. If you want to be kept private, then basically turn off your camera and don't speak. For board meetings, there's also not an expectation of privacy. That being said, I don't know if you noticed when you logged into this Zoom, but Zoom tells people it's being recorded and you have to click OK. Or you are given the option to hit OK. So if you are recording it, tell the owners, you can even announce it if they won't notice the little pop-up box. Tell the owners that the meeting will be recorded. And then they can decide if they want to be recorded or not. Obviously, they can choose not to talk, or they can leave if they don't want to be recorded. So also keep in mind that the transcript that Zoom produces or the video recording is not the official record of the meeting, only the minutes are. So if this practice is working for you, you can keep doing it, but just remember that the official record of the association are the approved meeting minutes. There's no expectation of privacy in these open board meetings, Zoom, or if the meeting were in person, or on another digital platform. There, regardless of the location, virtual or physical, there's no expectation of privacy, but you can always tell people and they can make that decision for themselves. Ken, do you want to add anything?
No, I'm good. So next question is, can an HOA function without bylaws? What are the risks of doing so? So the answer is, well, yes, you can function without bylaws because the statutes will fill in virtually all of the necessary parts of what bylaws would do. And often when a client doesn't have bylaws, the necessary parts, which is mostly the number of board members, will be contained either in the Articles of Incorporation or in the CC&Rs or the condo declaration. Okay. So especially beginning January coming up, 6490-445 is going to cover 80 or 90% of what bylaws would normally do. So you don't need to adopt bylaws, you can just follow that statute. And if it doesn't have the number of board members in it, which the statute does not, then you need to look to your declaration, CC&Rs, or Articles of Incorporation to figure out how many board members you have. Okay? That's the only thing I can think of that's actually going to be missing that might affect the governance of the community, which is what the bylaws do. The bylaws are supposed to supplement the articles of incorporation. If you are not a condominium, then you're not currently required to have articles of incorporation and be registered with the Secretary of State, but effective in 2028, every association across the state will need to be registered with the Secretary of State. There are defaults in the statute 649445 for how big a quorum is, and there are all the requirements for how notice is provided and how to vote. So you can certainly get by without a set of bylaws. And if you've got a set of bylaws now, they're going to be inaccurate starting in January. You don't have to change them. You just need to follow the new statute. And there are certainly some potential circumstances where you'd fall back on the Nonprofit Corporations Act, or if you're a WUCIOA community, the LLC Act for some, I'll say minutia about how you govern your community. But otherwise, the bylaws are to help you make decisions as a community. They govern the conduct of the association, not the use of the property. Anything you want to add, Katie?
You covered it. So our next question is, if an owner is caught doing something illegal by a board member, manager, or on camera, what steps should the association take? So if there is an active crime, it is reasonable to contact law enforcement. The association is not law enforcement or a guarantor of safety, and really can't do much in an immediate active crime. I mean, for obvious reasons, if someone's committing a crime, there's no obligation of a board member or manager to try and stop that crime from happening. That in most situations, but it largely depends on what the illegal activity is. So are we talking about theft, speeding, failing to renew car tabs, which is technically a crime, assault, vandalism? Depending on what it is will impact what you do. But again, if there's an active crime, contact law enforcement. They are in a better position to handle it. And once they handle it, then the board can decide if any additional steps should be taken from the association's perspective. Because sometimes an illegal act may also violate the rules or CC&Rs. For example, we have a lot of associations where owners are required to have car tabs that are current with Department of Transportation. So technically, that is a crime and would violate the rules. So the board could take their regular enforcement action and enforce fines after finding a violation and offering notice and an opportunity to be heard. But this is the action of the whole board, not just one board member. And it's something based on, as I mentioned before, objective information and adequate inquiry. One board member or the manager could report the violation to the full board for consideration, but it's not one board member acting alone and making that decision. Also, the board could decide to do nothing, especially if it doesn't concern the association or the common elements, or is not considered material to a reasonable person. Ken, do you have anything to add?
Well, I just would add that WUCIOA is providing some clarity on the duty of a board to enforce the governing documents. And that's in section 6490-405. I think it's sections
7, 8, and
7,
9.
8, and 9. And it actually talks about the ability of a board to disregard a violation or a reported violation that it considers to be inconsequential or perhaps inconsistent with law, or just not in the best interest of the association to enforce. And this, we think, represents how the courts have interpreted the obligations of boards to enforce the declaration. So even if something says you must strictly enforce the rules, regulations, and CC&Rs, If you've got a violation like a person parking in their driveway and you don't care, even if the declaration says you can't park in your driveway, there is not an obligation for the board to strictly enforce it based on the criteria of 6490, 405, 7, 8, and 9. Next question is, under the new WUCIOA rules, which may require boards to meet more frequently, would it be acceptable to consolidate the minutes for the entire month to include all meetings held that month? We envision short meetings necessary only to approve items that can't wait for the next regular monthly board meeting, such as approving a contract for work to be done. Unnecessary meetings will be canceled. So the short answer is no, we don't think you can consolidate the minutes from multiple meetings into a single set of minutes. You could have all of the meeting minutes sequentially on the same document, and you could approve them all at one monthly board meeting, but it should be clear what actions were taken at each date that the meeting met. And, I don't know that there's a strict rule for or against, but I do think it's going to be important that you be able to trace the action of the board to a specific meeting date, whether you approve all those minutes together or whether you approve them separately. Anything you want to add?
Nope. So our last question submitted in advance is, our condominium was built prior to May 1990. So we currently fall under RCW 6432. For the upcoming Washington Uniform Common Interest Ownership Act, WUCIOA, which is 6490, are we required to amend or change our governing documents, or is the only requirement that the HOA and the board of directors comply with all aspects of the new law if and when they are in conflict with our current documents? If we are required to change our governing documents, what are the minimum changes that are required? If no changes are required, what are the minimum changes that you recommend? So we will keep saying this, we've said it before. You are not required to amend your governing documents. You are required to comply with the statute. So there are already parts of WUCIOA that you would be required to comply with. For example, the budget is one that is currently everyone has to apply to, comply with. Starting January 1st, 2026, everyone will have to comply with the meeting section. Note, for 6432 communities, there are parts of the Condo Act, which is RCW 6434, that you also have to comply with. But again, you are not required to amend or change your governing documents. The statute will apply regardless. The requirement is that you comply with the changes to the statute, whether or not you make any changes to your governing documents. So your practice needs to change, even if your documents don't. If you don't want to adopt a restatement, if you don't want to change all your documents altogether, you could adopt targeted amendments instead of restating. If you want to address just the meeting changes, you could just amend your bylaws without amending your declaration. You could also have a law firm draft a memo of conflicts between your documents and the statute that can be given to owners so they know what the differences are and when the statute will prevail over your governing documents. As of right now, the minimum changes we would recommend would be those required under RCW 6490 445, so the meetings provision, and RCW 6490 502. We also recommend at least looking at your collection policy based on the changes to the collection notice requirements that are applicable to everyone January 1st, 2026. Those changes are mostly related to late fees and what notice you have to provide. So a policy update would be more appropriate than a declaration update. Ken, do you have anything to add?
Yeah, so first I'll offer that the section 502 that Katie mentioned is about emergencies because it clarifies the board's ability to act in an emergency like a fire. Um, and in terms of recommendations, part of why, at least I recommend you just go ahead and do the bylaws is that in most cases, it does not require a recorded document, so the cost is low. In most cases, the threshold required for voting by your memberships is lower than that required for your CC&Rs or your declaration. So that makes it easier to do. And also it avoids the problem of people bitching about how you're not complying with the bylaws when you are complying with the statute, which overrides the bylaws, by making the two documents match. There are a lot of people who have this mistaken belief that their bylaws control over the statutes. And so you can just silence them in advance by making the bylaws match the statute. And for the most part, there's not anything controversial in the section 445. You may not like it, but there's not a lot of dispute about what it says. And so you can adopt bylaws, which are, 90% just copying that provision of the statute, insert your board members provision. If you want to adopt some optional provisions like a code of ethics for your board or a communication and anti-harassment policy, you could certainly do that. But you could also just make it really straightforward and stick to the statute. And again, because there's not a requirement to record it, the cost is relatively low. Anything else, Katie? Are we
Nope. So
doing
turning
questions?
to the chat, our this is the most recent question, but I'm just going to answer it first because it was quick, and then I'll go back up to the top. So, must the board have copies of any materials they are using to make decisions available at board meetings for owners attending, or do they only have to comply if asked? So, the new statute specifically says that materials used by the board must be made available to owners. They do not have to be sent out in advance. So if someone asks, you have to give it. If not, you don't. The only exception is for materials used for discussion that will take place in executive session, and unapproved meeting minutes do not need to be provided, even if asked. So going back up to the top, can a condo association legally set up a GoFundMe to raise money for new playground equipment? Ken, do you want to start with that?
Well, I can't think of a reason why a association couldn't adopt a GoFundMe to try and fund a project. Some associations have provisions that say that you can't do capital improvements without an affirmative vote of the owners, but it certainly anticipates that you're spending association money. And I suppose if you set up a GoFundMe, you're not spending association money, you're spending contributions from volunteers. So probably that wouldn't be applicable. So I guess I'd probably want to know more specifics. So I'd advise you talk to your attorney about what the scope of that playground is and make sure that you do it in a manner that's not going to create tax consequences for your community as well. So too
That's
detailed to answer in full.
Yes. So I think we touched on this, but just to confirm, when the board reviews the reserve study, do we vote to accept, adopt, approve, or just say thank you very much and do whatever we decide is appropriate? So I think we kind of you touched on this at first, is basically if with the disagreement question, is you can decide whatever you want, but you don't vote to approve it, you just accept it because you can't change the reserve study professional's opinion, especially without their knowledge. Is that
Yeah, I would say it's the same as getting a CPA audit. Um, you don't get to change the CPA's opinion about your accounting. And I think that it is appropriate to have the meeting minutes reflect that you have received the audit or received the reserve study. Um, some clients say they accept it, but accepting doesn't necessarily imply agreement. And some clients will just have a note that says they have received the reserve study or the audit as required by statute.
All right. The next question is, can an owner run for a position on the board if they are in poor standing with the association, they're being audited for a longstanding delinquent account? So we can't answer this question for your association specifically, uh, but generally qualifications for board members must be set in the bylaws. So going back to our conversation earlier about what would you want to include in your bylaws, any restrictions on an ability for a person to run or serve on the board, that might be something to put in your bylaws if you don't have them and you want them. Otherwise, there's not much that can prevent an owner from running, except that the community can choose not to elect them.
So I will offer that WUCIOA does specifically address owners who are delinquent and who have been told they are delinquent and they have failed to cure the delinquency within 30 days. So you can prevent a long-standing delinquent owner from being qualified to serve on the board. And the statute has a provision to allow you to remove a delinquent board member from the board if they've been given notice, they don't cure it, and then the board votes to remove them. I think it requires a 2/3 vote of the board members. And unfortunately, the delinquent board member gets to vote.
Okay, in the new open board meetings, can late assessments of homeowners be discussed? Can foreclosures be discussed? So I'm going to I was going to start with the foreclosures, but in general, there is still an exception in this open board meeting requirement for executive session. And the statute specifically lists what items may be discussed and are appropriate for executive session. So the obvious ones are consulting with your attorney, reviewing a legal matter, discussing a contract that's currently being negotiated. And then there is a kind of broad one, which is to discuss anything that would like public disclosure would invade someone's privacy. So there is a current discussion that is not settled, I would say in Washington, about whether or not delinquencies would fall under that category of something where public disclosure would violate someone's privacy. I know associations on the East Coast, which we're not, but they take the approach of, you're delinquent, that's too bad. We're going to put everyone on blast, if you will, and share that. So the board does have discretion to decide if delinquencies in general, not a specific delinquency, or I guess, or specific delinquency, would warrant discussion in executive session. There may be other circumstances regarding a specific delinquency that would warrant a discussion in executive session. Say the delinquency is related to some health concern, and that's why they want to talk about it. So in general, the board can decide if something warrants executive session or not for delinquencies. But it's only the discussion about the delinquency that would take place in executive session. The actual vote on whether or not to proceed with a foreclosure or send something to collections, that takes place in the open board meeting. So if you're concerned about telling everyone in the community a specific person's delinquency, you can use unique identifiers so that the board knows who to proceed with. with the collections action, but kind of adds a layer of anonymity. So using a lot number instead of a last name, using a generated code where you can track who, an account number where people can track who's who, but you don't need to put it in the minutes. Maybe a way to still have the discussion in an open meeting and at least have the decision reflected in the minutes without saying Mr. Smith in lot 7 is being foreclosed on. For foreclosure specifically, that decision the decision of the board to proceed with a foreclosure by statute needs to be reflected in the meeting minutes of the board. So just keep that in mind procedurally moving forward. Even if you don't want it to, that's a statutory requirement. Ken, anything you want to add?
I guess a couple things. You commented, and I agree that it's a board decision on whether or not an issue is going to violate the privacy of an individual owner. And so that would mean the board has to make that decision. In part, you have to, when you make the motion to go into executive session, state why you're going into executive session. So that might be the time it's done. I suppose it'd be possible for the board to adopt a formal policy where you set out criteria for when delinquencies would be discussed in executive session. It's not possible to prevent owners from finding out who's delinquent, though, because the financial records of the association are going to be available to all owners. So if someone really wants to know who the delinquent owners are, they have the right to review all the financial records of the association, which would show which owners have not been paying their dues. So we certainly have a sort of Northwest tradition of discussing delinquencies in closed sessions. I don't know if that's the right thing to do. I don't know if it's benefiting the community or benefiting those owners absent some special circumstance. And I don't know, because we haven't had any challenges to this kind of thing in the courts yet, and we may not for some years. I don't know how the courts would view a discussion of delinquencies and whether it's a financial matter that all owners should be entitled to know, or whether it is something that has some privacy concerns that legitimately are done in executive session.
All right. So just for people who've submitted questions, I'm skipping a few because they're just too lengthy to get into right now. So if I skip it, feel free to send it to info@condolaw.net for next week. But our next question is, can where'd it go? Can owners vote for a budget electronically over email since there is no secret ballot requirement? So currently for non-UCIOA communities, there is no secret ballot requirement. Keep in mind that that will change and there will be a secret ballot requirement for specific things listed in UCIOA, such as voting on amendments. And I think board of directors are another one where there's a secret ballot requirement. So the question is, can owners vote for a budget electronically? So the budget statute, in general, your budget is ratified unless it is rejected at a meeting by a majority of the owners. So there needs to be a budget ratification meeting. Now, whether or not people could send in their ballot by email at that meeting, I might let Ken talk about in a minute. But I would say the short answer is they can submit the ballot however needed, but if no ballot is submitted, one, that's okay because the budget's ratified regardless if they vote. Two, if they are submitting an electronic method, you have to be able to confirm that they are at the meeting rather than from just emailing in from anywhere. And the meeting can be virtual. So you could have a virtual meeting where people email their vote in, but again, you just have to make sure that they're at the meeting. Ken, do you want to add anything?
Well, the voting sections of all the statutes provide that members can vote at a meeting in person, by proxy, or by absentee ballot. And then there are specific requirements for absentee ballots, which is that they have to be prepared by the association. So you could, as an association or as a board, produce absentee ballots and send them to the owners that the owners could use either by mailing them or sending them electronically to vote at the meeting because the statute provides for that. Most of our clients don't want to make it easy to reject a budget, so they don't send absentee ballots. If you don't send out absentee ballots, I don't think you can have electronic votes coming in by email to reject or approve the budget at the meeting because the statute's specific about how absentee ballots work. If you've got more detail that you need on that, you need to talk to an attorney about your specifics.
So the next one is, could you clarify whether under RSW 6490-525, proxy ballots can be mailed before the budget ratification meeting and used to reject the budget, and whether a majority of the owners must be present to do so? So as we just discussed, the budget is ratified unless it is rejected by a majority of the owners present in person, by proxy, or if prepared absentee ballots, by absentee ballot. The statute does not require that the association affirmatively prepare proxy ballots, but the association is required to accept proxies if they comply with the certain requirements of the statute. So whether or not you send out a proxy ballot somewhat doesn't matter if the owner submitting the proxy complies with the statutory requirements to create the proxy, basically saying that it's a proxy for this meeting. It can be directed for a certain vote, or it could just be to give the person who holds the proxy the power to make whatever decision they want. It doesn't need to say, but it can only to reject the budget. That is different than absentee ballots, which the association, if they're used, the association has to create. The association does not have to create proxy ballots. It can.
Well, I sort of thought maybe the question was asking if you could reject proxies that were not presented at the meeting. And my answer would be if a proxy was submitted a week in advance or a month in advance and stated it was assigning the proxy to someone who's in attendance at the meeting, then you have to accept it. You can't make this tiny window of opportunity for proxies to be submitted. Part of the purpose is to have the budget ratification reflect the true opinion of your membership. So if you artificially restrict how people are allowed to participate at the budget ratification meeting or how they are allowed to vote at the budget ratification, you are creating risk for your community having that ratification challenged, and we would recommend you avoid that risk. We want to encourage you to find ways to let all of the members' voices be heard. And if that's through proxies or absentee ballots, then that's the way you should do it.
Can I ask a quick clarifying question on the ratification?
Sure.
In the hybrid world we're living in now, it's more challenging to verify residents when they come in on Zoom or on the phone. Do you guys have any recommendations on best practices to do that?
Well, I think if you are looking at a vote which is really close, you're allowed to do that verification after the fact. So if you're not sure who it is on the Zoom or if people are actually the ones voting electronically, you could send emails out to confirm their vote after the fact in order to make sure that the results you got at the meeting are accurate. So hopefully that answers the question.
Thank you.
And I think with that, we are done for today.
Yes. Thank you all submit your questions for next week if you have them, and see you then.